is for a divorcing spouse to inherit some of your property. You know, so this allows a little bit of control from the grave in who's going to inherit, how they're going to get the distributions. With a will, if you just have a will in place, your administrator is going to liquidate the estate, write a check. Of course, that's simplifying things, but they're just going to give the beneficiaries whatever they're entitled to outright. And so it doesn't offer any level of protection where a trust will allow that level of protection. So as I mentioned, it will also avoid a probate, but it also gives you that flexibility. Okay, so funding a trust, in order for a trust to work as it's supposed to work, you have to transfer your assets to the trust currently. So, for example, I'll use the example of a house. What we would do is a new deed to the house, transferring it from you individually to you as the trustee of your trust. It doesn't in any way impact your ability to transfer the property, sell it, refinance it. You still are the owner of the property. You're just owning it as the trustee as opposed to as an individual. And why that is important is because the deed will say, or my successors. You know, I own it or my successors. So then what happens is that, again, like I mentioned previously, upon your passing, your trustee can step in immediately and do whatever needs to be done, whether that's transfer the property, sell it, whatever. Did you have a question?
I just have a question really quickly. Repeat the question for us. Okay. So you had mentioned the difference between the trust and the will.
Mm-hmm.
So the will, does this happen immediately? You've been mentioning that with the trust, that it's right upon your passing.
So
the trust goes into effect. Does the will occur immediately?
That's a really good question. So a member of our audience just asked if the will takes effect immediately or transfers immediately, as I've been saying with the trust. So with the will, what happens is that upon your passing, your executor has to go through the probate process before anything can be transferred. So in New Mexico, the probate process isn't that big of a deal, but it is a process. So it takes, even in a simple probate, you're looking at about 6 to 9 months, and it's an added expense to the estate because you have to pay the court fees, you have to pay to, you know, have a attorney go through the process for you. You have to publish notice to creditors. There's just a process that you have to go through. So while the appointment of the administrator, the personal representative, executor, all those terms are kind of interchangeable, that happens immediately, but they can't transfer the property until all of the creditors' claims have come in and they've determined what's going to be left in the estate before they can make distributions. With a revocable trust, the trustee can step in. There's no need to publish notice. You don't have to notify anybody. Nobody knows except for the trustee what that trust document says. And so they can step in and administer the estate. Now, with that being said, that doesn't mean that they don't have to pay creditors' claims. They're still going to be responsible for those, but they don't have to wait. So oftentimes the situation is that, you know, okay, this is about what the creditors' claims are, and let's say the creditors' claims are $20,000 roughly, and the total value of the estate is $200,000. Well, then you know that you're going to be able to at least distribute $100,000. So you might have to put a little bit aside to pay those creditors' claims, but you don't have to wait. The trustee does not have to wait. They have the ability. And the biggest thing is not even the distributions, but just being able to step in and say, put the house on the market, or start the process of getting things done. So if we go through the probate process, you can't do that until you've been appointed. You can't start the process until you've actually been appointed as personal representative. Does that help? Does that answer your question?
You still have to go through probate with the will.
With the will, yes. You have to go through probate with the will Unless you use the transfer on death deed that I mentioned, that works like a beneficiary designation. So that's going to pass to the intended beneficiaries immediately. The problem with that, and I will tell you, in some instances, it's perfectly fine. It's perfectly acceptable, and it'll work like it's supposed to. But I'm going through one right now. I have a family who their dad passed away, left a transfer on death deed to the 5 children in equal shares. Well, all four of the children are totally agreeable. We just want to get the house fixed. We want to sell it, to divide the assets. We've got one who doesn't want to do it. And so it's holding up the entire process. And it's getting expensive because, you know, had they been able to sell it 2 months ago when the market was red hot, it would have been easy, you know, but now the market's starting to slow down, and just there's all these things. They're having to maintain the house, you know, they're having to keep the yard, just everything. Just it has been it's turning into a money pit. And it's all because the one child doesn't want to sell it, and it really doesn't have a good reason for not wanting to sell it. It's just kind of trying to make everything difficult. So that is the downside to a transfer on death deed, is that everybody has to be in agreement. If you're leaving it to one person, much simpler. The other downside to simply doing a transfer on death deed is if there are a lot of creditors or not even a lot, if there are some creditors in the estate, and maybe the only asset or the primary asset that an individual has is the home or the real property, and it passes automatically to someone, well, then those creditors are left in the cold, and they're not going to be happy about that. And so they can come back then and try and collect on that property. And what happens is that your personal representative is the one who has to be at the brunt of that. They have to fight that battle, not the person who inherited the property. The personal representative isn't going to be personally liable, but they might have to go after the beneficiary who inherited the property, collect the property, sell it, and then pay the creditors. So while I consider a transfer on death deed a Band-Aid, it will avoid probate, but there are other potential problems that are inherent in using a simple transfer on death deed. Yes?
So I've been told that when you put a home into the name of the trust, the county considers it a sale, and your property taxes may go up.
So the question was, if you put a piece of property into a trust, is the county going to consider that a sale and increase your property taxes? So in a typical situation, that's not going to happen. The bigger question that comes into play sometimes is the mortgage going to become due? Is the mortgage company going to call it a sale and make it, you know, and call the mortgage? For the most part, that's not going to happen either. But it is something that could, you know, a mortgage company could bring that issue up. A transfer to a revocable trust is something that is permitted in most mortgages, unless you have this really old mortgage and most people don't anymore. If they purchased the property that long ago, the mortgage is paid off. So, but most recent, I haven't ever seen a mortgage that did not have an inclusion for a transfer to a revocable trust. That being said, I typically will tell my clients there's not even a need to inform the mortgage company that you've made this transfer, because you're going to continue to pay it. You're going to continue to make the payments. That's what they're concerned about, is they don't want to see you trying to transfer it to get out of the mortgage. You're still going to be responsible for paying that mortgage. With the question you raised about the property taxes going up, I've never seen that happen. This is the first time that I've ever heard that. So I don't want to say 100% that is not a possibility, but I have been doing this for, like I said, 23 years, and I've never seen that happen. The title company, the county clerk does get notified when a transfer to a trust is made, but it doesn't impact the property taxes from what I have seen. Okay, let me see if I did everything here. No, actually, so I talked about transferring property to your trust, but with respect to the other assets that you may own, investment accounts, bank accounts, in a typical situation, my recommendation is that you don't transfer title, but what you do is you make those accounts payable on death to the trust. And the reason for that is it just simplifies the process. So many times, especially with like brokerage firms, they're going to, if you wanted to retitle the account, they're going to make you close your account and open a new account. And that's just not necessary. So you can make your bank accounts, investment accounts, anything like that, payable on death. So it won't take effect until you're passing. But then when you pass, it automatically transfers immediately into the trust and will be distributed pursuant to the terms of the trust. That is typically a better way to handle bank accounts and any kind of financial institution accounts. With respect to life insurance, you don't have to name the trust as the beneficiary. And a lot of people will say, oh, I've already divided it. It goes 50-50 to my 2 kids. That's fine. That is going to avoid a probate. But the problem with that is, like I mentioned previously, they're going to get a big check, you know, for $100,000 or whatever the payout is. And are they necessarily going to do the right thing with that money? Whereas if you name the trust as the beneficiary of a life insurance policy, they're still going to get it, but they're going to get it under the terms of the trust. So the trustee has that ability to withhold distributions if it's not in their best interest. Little side note, it's important to understand that your trustee, regardless of whether or not they're withholding distributions or making an outright distribution, their number one job is the best interest of the beneficiaries. What's in the best interest of the beneficiaries? So if they determine that it is in their best interest to make a distribution, then they have the obligation to do that. But if they decide that it's not in their best interest for whatever reason, maybe like I mentioned before, going through a divorce or something, then they have the authority to withhold distributions for a time period. Qualified retirement accounts, I won't go into a lot of detail about that because it just depends on the circumstance, but I would always say talk to somebody who knows because there are tax implications for changing beneficiary designations to a trust. So before you do any of that, talk to somebody that knows. Okay, powers of attorney. Powers of attorney are, in my opinion, just as important as having a will or a trust, in some cases even more so. And the reason is because if an individual reaches a point where they are incapacitated, whether it is a mental incapacity or a physical incapacity, and they no longer have the ability to handle their financial affairs, a guardian and conservator is going to have to be appointed in order to handle that, unless you have a power of attorney in place. So a guardianship and conservatorship, that is beyond the scope of what we're talking about here, but I'll tell you that it is a very costly, very time-consuming legal court procedure in order to be appointed as a guardian and conservator. So with a power of attorney, you are naming who you want to step in and handle your affairs in the event that you become incapacitated. There are springing powers of attorney or durable powers of attorney. Durable power of attorney takes effect immediately, and it is will carry you through your incapacity. The springing just doesn't become effective unless you become incapacitated. So in a typical situation, husband and wife, they become effective immediately because they're able to do anything anyway. But then with respect to a successor, so if it's your child or a friend or whatever, they have a springing power. It's not going to become effective unless and until the person becomes incapacitated. But it allows you to give them grant authority or limit their authority, however suits your interest, or however suits your situation the best. But it's like I said, it's just as important, or maybe in some cases more so important, than having a will or trust in place. Okay.
So if you don't have a power of attorney, is the guardianship or the conservator left court appointed?
Yes, so the question was, if you don't have a power of attorney, is the guardianship court appointed? And yes, they are court appointed. You have to go through a proceeding. So an individual, say your son or something, you know, is going to step into that role, then they petition the court to be appointed as guardian and conservator. The difference, guardian is handling your physical body. Conservator is handling your affairs, your financial affairs. And so in most situations, a person is appointed for both. And just briefly, how that process works is that the individual has to petition the court, and then what the court will do is they will appoint a guardian ad litem, which is an attorney, separate from the attorney who is representing the petitioner, a court visitor, and a healthcare provider. And all three of those people have to meet with the incapacitated person and report back to the court. So you can see why it gets, and you know, how it gets to be so complicated and expensive, because you have to pay all these people, you know, to serve in that role. And you have to report to the court annually if you are appointed. Yeah, you have to provide a written report each year, what you did, and you know, of all of your transactions. So it's a very in-depth process, and it gets expensive to do that. Healthcare directives. So a healthcare directive can include several components. My healthcare directives include four medical directives. One of them is a right to die or living will, whether or not you want to be kept alive by artificial means. It includes a healthcare power of attorney. So separate from the financial power of attorney, it allows you to designate an agent to make healthcare decisions on your behalf, not just end of life, but all healthcare. It includes an anatomical gift designation, which is basically just what's on your driver's license, whether or not you want to donate your organs and tissue, or a portion of them, or let your agent decide, or whatever. And then it also includes a HIPAA release. So it gives your agent the authority to access your medical records if it becomes necessary for them to do so. And like the power of attorney, it can become effective immediately or can become effective upon your incapacity. Personal decision. You know, I typically, unless there's a reason, and unless it's a spouse, I typically say, let's just make it effective when it becomes necessary upon your incapacity. Yeah, so healthcare directives, go ahead. Next.
I have a crazy question about healthcare directives.
Yep.
What if in your partner's healthcare directive, they want you to do something that might not be completely legal when they're ready to die? Like, for instance, be fed to a bear.
Oh.
Because that's the way they want to die and not any other way.
So the question is, what happens if one of you, if the person creating the healthcare directive wants the agent to do something that is illegal or
Maybe not moral.
or immoral. I don't upon their passing. So she said,
or even before their passing, so that's the way they.
So that's the way that they pass. Yeah. Well, you can't do that. You can't do any. I mean, I guess you could, but you know that you're not going to be protected if it's something illegal, you know, and if somebody comes after you for doing it. Yeah, you can't, that's right. Right. You can't say, but it says right here that that's what he wanted me to do. Yeah, unfortunately, you can't do that. Although I've seen some crazy, I'll tell you a funny story, and this is very recent. I had a client who, in a burial directive, wanted a portion of his ashes to be saved and transported to the moon by hopefully one of his heirs. Yeah. So it's in there. That's what he wanted, you know, but is that going to happen? Probably not, you know, but who knows? It could, who knows? Okay, so a burial cremation directive, this is, yeah, a little bit different, goes beyond the about healthcare directive, and this is with respect to your actual burial. So maybe not getting eaten by a bear, but, you know, if you want your ashes to go to the moon, this is where you would put it. So that's kind of the documents that create an estate plan. As I said, you know, there are so many different variables, and it really depends on your individual needs, what's important to you. That's the first question. You know, what are your goals? Is your goal to simply avoid probate, or is your goal to protect your heirs, your beneficiaries? So when a client comes into me, I said I was going to give you an example, and this is might be pull things together a little bit. So if a client comes in and they say, I need a simple will, I don't have much, I own a home, and I have a little IRA and my bank account, and I have 2 children. One of them is in college, one of them is in high school. And I just want everything to be divided equally among them. And let's just say, for simplicity purpose, well, no, it's a married couple, they come in. And so what they tell you is, I just want a will that gives everything to my surviving spouse, and then upon the surviving spouse's death, everything gets divided between the 2 kids. So my first question to them is going to be, what are your goals? What are you trying to accomplish by doing this? And they'll say, I just want it to be easy for my kids. I just want them to be able to go in and take charge of my assets. So then my response to them is, okay, well, let's talk about if we just do a simple will. And what's going to happen is that they own this home, they own their bank accounts. Let's just say that they don't do anything. They don't do any planning, like I mentioned with the transfer on death deed or the payable on death accounts. They don't do any of that. So, they name their 2 kids as co-personal representatives of their estate. So what's going to happen is that upon the passing of the second to die, the 2 kids are going to petition the court for appointment as personal representative. They're going to have to publish notice to creditors. It's going to go for about 6 to 9 months. And then they'll be able to, once they're appointed as a personal representative, then they'll be able to transfer the house to the 2 of them. And they can sell it and divide the assets, whatever. But I stop talking with my hands. But what will happen in that situation is that they have to go through the court proceedings. It's going to take time. It's going to cost about, in today's market, a simple probate, not contested, you're looking at between $2,000 and $2,500, $2,000 and $3,000 to do a simple probate. And they're going to take that money and maybe, so let's say they own a $500,000 home, it's all paid for. Each kid is going to get a check for $250,000, right? Okay, so that's the house. And then the bank accounts, oh, there's not much in there, so I'm not too worried about it. And they're, again, going to have to get the appointment as personal representative before they can get access to the bank accounts. Then they can go in and clean them out. The IRA, I've named them as the beneficiaries, so it's all good. You know, they'll get that without the need for a probate. So the biggest issue in that situation is the process, the probate process, and the outright distributions, because they're young. You know, they're college age and high school. If I think about what I would have gotten or what I would have done with the outright distribution at age 20 or even age 25, you know, and I probably would not have been smart about what I did with that money. So, and they won't have any control over that. So let's say 10 years down the road, oldest child is married and has kids, but maybe it's not the best marriage. And so they're in, you know, a divorce is potentially on the horizon. Well, then that divorcing spouse could get a portion, could get half of whatever that child inherits if they get an outright distribution. That sentence alone is typically enough for someone to say, yeah, okay, I want to do a trust. You know, because and what I tell people is you're either going to pay for a trust now, because yes, it is a little bit more expensive than doing a will, or you're going to pay for probate later, or your state's going to pay for the probate later, and have all these hoops that they have to jump through in addition to the fees associated with it. So at that time, they're set. You know, they'll typically say, okay, yeah, I think that the trust is the better way to go. But most people think, oh, if I don't have a lot, then a trust isn't necessary. And there are so many other benefits to having a trust. It used to be that, yes, revocable trusts were used primarily for estate tax planning purposes. Well, now with the exemption, the annual or the gift tax, estate tax exemption amount being so high, it's now over $11 million. So a married couple can pass with $11 million in assets and there is no estate tax. But it used to be that that was $1 million. And so that impacted a lot of people. Now, not so much, but there are definitely other benefits to having a revocable trust in place. I think that, there was one other thing that I wanted to touch on when I was going through the example, and it was, this kind of goes beyond what we're talking about here today, but as I mentioned, there is a level of asset protection for your beneficiaries, not for yourself. And so I do have a lot of clients who are concerned about long-term care, going into a nursing home, and I don't want all of my assets to get eaten up paying for a nursing home, you know? So there are other tools in addition to what I've mentioned here that kind of go beyond the basics of an estate plan, but there are definitely ways that you can protect a portion of your assets, a portion of your estate from Medicaid or from the government, so that you can apply for Medicaid so you can get into a nursing home. And I'm happy to, you know, answer questions about that if anybody has questions about it, but it's kind of beyond what we were scheduled to talk about. So I don't want to go down that path unless people want to hear about it. Questions? Yes, ma'am.
So I'm a little bit on the younger side. I have 2 children who are minors, and what would you recommend I have in place should something happen to me before they reach the age of 18? I don't own a house, I'm a renter.
Okay.
It's really just custody of my children.
Of your children.
It would not be in their benefit to go back with their father. So what would you recommend?
Yeah, in a situation like that, that is, so the question was, a younger individual has 2 minor children. What would I recommend when the primary purpose is to protect the kids, right? Make sure that somebody is appointed to protect them. In a situation like that, because you don't own a home, a trust might be overkill in this situation. A will allow you to appoint a guardian for your children. Now, if their dad is involved in some way in their lives, he's going to have priority, even if the will says that you want them to go to someone else. But the will is what's going to take effect, and then he would have to be proactive in coming forward to try and get custody of the kids if that's what he wanted. And I will say that in New Mexico, courts are very pro-parent, and regardless, unless there is some evidence of abuse or that this person is just unfit to be a parent, courts are going to give preferential treatment to the surviving parent. And I tell you that just because you need to know, yeah. But absolutely, my recommendation would be put it in a will, you know, that that this is the person you want to take your kids.
And the unfit part would have to be documented, right?
Right. Police report, yeah, the question is, and the unfit portion would have to be documented somehow, and that's absolutely true. If there is no prior record of that, but you know that it exists, then you or your guardian, whoever you've named as your guardian, because you'd be gone, would have to petition the court to bring all of that to light and make those accusations.
Is that the case even if you have full custody?
If you have sole custody from a court appointment, is it a court appointment because of unfit? Then yes, then you, if that's the case, if you have sole custody and a court has already determined him to be an unfit parent, then you could name the guardian and he would not be able to come forward. Yep. Any other questions? Yes, sir.
What about like valuable personal property, like tangible personal property? What's the proper way to transfer that into a revocable trust? And how does the trust typically deal with that?
That is a great question. So the question was, what about personal property, valuable personal property? How do you deal with that? How do you transfer it to a trust? How does the trust handle it? So it depends on the asset, for number one. If you have, let's say stocks, I'll go through, do you have something in particular that you're concerned about?
Like a ring, like a
Okay.
valuable ring.
Yeah, so there are a few things that you can do. When you establish a trust, you can do what's called an assignment of personal property, and that is going to address all of your personal property. And it basically says, anything that I own of a personal nature, I want it to go into the trust. I want it to be distributed. Only things that have title, so a yacht, and I'm talking about expensive things that have title, because automobiles, we don't have to worry about transferring them to the trust, but a house, a yacht, maybe brokerage accounts, if you own stock certificates, all of these types of things are title driven, so you would have to do a transfer of title into the trust. But with respect to personal property, just an assignment of your personal property would handle that. As far as distributing the personal property, there are a couple things that can be done. In New Mexico, we have this really cool thing. It's called a tangible personal property list, and it allows you to designate who you want to inherit specific items of personal property. And this, under the New Mexico statute, this list just needs to be signed and dated. And so you can update it at any time during your life without without going to talk to your attorney or updating your documents. And as long as the list is signed and dated, the trustee or the personal representative of your will has the authority to transfer those assets, to give those assets to whomever you've named. If they are not included on tangible personal property list, then the trustee has the authority to either liquidate or, so when you talk about a trust or an estate, whether it's through a will or a trust, if you think of it like a big bucket and you're just putting all of your assets into this bucket, so your trustee, their job at the time of passing is to evaluate that bucket, and they put a value on it. So it doesn't necessarily mean if you say then, okay, my estate is going to go 50-50 to my two kids, doesn't mean that they each have to get 50% of each asset. It just means they have to get the value of 50% of the bucket. So if maybe your daughter wants mom's wedding ring and son wants dad's gun collection, then the trustee has the ability or the authority to do that. And it's called making in-kind distributions. So the entire estate doesn't have to be liquidated. The only time that becomes an issue is if both kids want the ring, right? Then the trustee can either liquidate, sell it, divide the proceeds, or figure out some other way to handle that. Does that answer your question?
Yeah.
Okay. Yeah, of course. Yes, ma'am.
Also, wills and trusts, do they have to be notarized?
Yes. So the question is, do wills and trusts have to be notarized? Both do. There are requirements with respect to will. So in addition, when you set up a trust, you also have to do what's called a pour-over will. So the two documents work in conjunction. They work together and the pour over will is kind of a backup document to the trust. You don't ever want to have to refer to the will, but if your trust isn't properly funded, then your will, the pour over will, says, I want everything to go to my trust, okay? So because you have to use a will in conjunction with a trust, then the laws with respect to drafting a will apply to both, whether you have just a will or a trust. And with a will, it has to be signed and it has to be witnessed by two individuals. In that situation, so it doesn't have to be notarized, but I'm going to tell you why you want it notarized. So if you have a will that is handwritten or written by a testator and witnessed by two individuals, that's usually the one that people don't do, is the two witnesses. They'll go take it to the bank and get it notarized, but under the law, it has to have two witnesses. But if something should happen and your will should be contested later down the line, then those two witnesses are going to be called into court in order to testify as to maybe your mental state or depending on whatever the will contest is about, okay? But if you have document notarized, in New Mexico, we have what's called a self-proving affidavit. And that is a notarized document that the witnesses and the testator, the person who's signing the will, state to the notary that we're all in this together. He and the testator understands the document. We, the witnesses, watched him sign, and we believe him to be who he says he is, and all this kind of stuff. That document, the self-proving affidavit, which is part of our wills, is what it has to be notarized, and that is what is going to keep the will from having to, from the witnesses to having to be called back into court if the will should become contested. Does that help? Does that make sense? Okay. So that's right. That's right. Yeah, there you go. So you can all do your estate plan right here. You've got a notary, you got your witnesses. Yeah, but like make sure you get it witnessed, because that's the thing. People don't do that. They'll handwrite a will, and it's so many times I've had people come in and families come in and dad wrote out a will, you know, and signed it, dated it, and thought that that was going to be sufficient, but it's not. It has to be witnessed. Yeah.
From Zoom.
Okay.
Relative to a trust, there are two actions: preparing the documents and funding the trust. Does the attorney help fund the trust? What is the bigger effort, preparing the documents or funding the trust?
Okay, that's a good question. So for those of you who didn't hear it, there are two aspects to a revocable trust. One is setting the trust up, and the other is funding. And the question was, does the attorney assist with the funding, and what is the bigger task, the setting up the trust or funding the trust? So funding the trust, with the exception of creating the deed, is not legal work per se. So the individual can fund the trust. That being said, we are more than happy to assist our clients with funding their trust. We write letters to the bank for them if they want our assistance. But a lot of times people don't want to pay attorney fees to do work that they could do on their own. So in most situations, I will say that my extent of funding the trust is preparation of deeds to transfer the property. But I will always send my clients with a written, this is what you need to do. You know, this is, go to the bank, you have these bank accounts, you need to go to the bank, you need to tell the bank you want them payable on death to the trust, and I'll give them the proper wording. So I do that portion for the client, but then the client does most of the legwork. So to answer the second part of your question with respect to which is more, which is, I guess, more difficult, or what was, I can't remember the exact term. The bigger effort. Probably funding, but it depends, because I have a lot of my clients have their house and their bank accounts, and that's pretty much it. So in that situation, then probably creating the trust is more difficult, you know, because I do the deed, and that's the harder part of the funding, and all they have to do is go to the bank. But if you have a long list of assets, you've got, and various types of assets, maybe stocks, stock certificates, bank accounts, investment accounts, life insurance, then it's going to require a little bit more work by the individual, for sure.
What's the typical expense for preparing the 5 documents and funding the trust?
Okay, so the biggest expense to creating the trust and funding it is typically the preparation of the documents. And how we handle it, and I know that not all attorneys do it this way, but we have flat fees for our services. And that is for the preparation of the documents. Assuming that you are a married couple with no real special provisions that need to be included in the trust, from beginning through end, it will typically cost about $2,500. That's the setup fee for a revocable trust. That amount will either go down if it is a individual, or it could go up if we have maybe special needs provisions. That's not something that I touched on here, but often we have people who need to protect government benefits that maybe their disabled child is receiving or something like that. So we often include special needs trusts in our revocable trusts, and those will add to the cost. Of course, doing a will is much less than that, about half the price of doing a trust, but it might have to be probated, which then is going to kick up the cost a lot more after the fact. Any other questions? No?
How difficult is it to instruct online banks to add payable on death designation?
So the question is, I'm assuming they can see it, right? How difficult is it to instruct online banks to add a payable on death designation? Most online banking has a form, so it's simply completing the form. I say most because I have come across online banks that didn't, and it was a little bit more complicated. But typically, it's just a matter of either completing the form or sending, finding their customer service, telling them what you need to do. It's not a difficult process to doing that. But every bank has their own process. That's the hardest part, I think, is that everybody kind of has their own hoops that they make you jump through.
I have a weird thing at my online bank. I did fill out a form and I got everything put in the name of the trust, the account put in the name of the trust, but they refuse to do online statements. They insist that if it's in an estate, they have to mail a paper statement. Right?
Really? Oh.
So, I mean, I literally put the whole envelope. I never open it because I have online access.
Right.
Shred it
Right.
every time it comes. I don't know why they won't.
Yeah. And that's a perfect example of everybody kind of has their own, procedure. And I don't know everybody's procedure, but yes.
So when I set up my will, I also made like a list of everything I could think of that I own. Keep that with the will to like assist my personal representative. My hope is that I'll update that from time to time. Is that something that you recommend? Is that like a standard part of the package when you advise clients?
It is. So the question is do I recommend that my clients keep a list of all of their assets and keep it with the documents to ease in the administration of the estate? Absolutely. I tell my clients, even if you just throw a bank statement, an old bank statement in your file, if you're not going to have a list, the more information you can provide your trustee about your estate, the easier their job is going to be. And so if you have a list, because I'll tell you, serving as trustee is not an honor, it's a job. And the easier you can make that job for them, then, obviously the easier it's going to be. And by just putting together a list of assets or who to contact, your passwords, all that kind of stuff, because now that has become something that is now included in our documents with respect to digital assets, because so many people have photos or whatever the case may be. So and online banking, so you want them to have access to all of that. So yeah, definitely.
When he's updating that list, does he then have to, can you just update the list, or then you have to get it re-notarized?
No, the list is a personal, that's completely separate. That's up to you. So it can be as formal or informal as you want it to be. And same like with the list of personal property assets. I have people who just scribble it on a piece of notebook paper. And as long as that list is signed and dated, it has the same effect as a typed out list with values and all of this kind of stuff, because under the statute, as long as the individual and the asset can be identified and the list is signed and dated, it's effective. So, that's up to you. And then the other thing, just briefly touch on, is I had said, that you can give your trustee discretion with respect to making distributions to your beneficiaries. And that too can be a letter that you write to your trustee and keep with your documents. And the reason that I typically will recommend that instead of putting it in the document itself is because that allows your trust document to kind of be a living document. And as your situations change, as your kids grow, as their situation changes, you don't have to go in and update your documents every time something like that changes. And you can just update the letter and say, whatever the case may be. If like, you really want them to primarily use this money for education before anything else. You don't want them to spend more than $20,000 for a car or things like that. Those are just guidelines for your trustee to be able to administer the estate in accordance with your wishes.
We had a question I'm asking for clarification. In your experience, how long does a typical process of doing this take from start to finish? But I don't know what doing this means.
I'm assuming that means creating the estate plan, setting up the documents, and I'll talk about that, and then the funding as well. But usually, when I meet with clients, what I will do is once we determine what it is that they need and what they want, I will give them a questionnaire. And that way they can fill it out on their own time. A lot of times guardian comes up and they go, oh gosh, well, I didn't think about that. I don't know. So rather than putting them on the spot, it allows them to complete it at their own time, where maybe husband and wife can sit down at the kitchen table and complete it together. So I will say that is usually what takes the longest in getting that form back, because once I get that form questionnaire back from them, I typically turn my documents around within a week, send them out for review, answer any questions. Most of and this was pre-COVID, but of course during COVID as well, most of my correspondence is via email. And I like to do that as opposed to a meeting or a phone consultation, because inevitably, if I explain something to the client in a meeting or over the phone, they go, oh yeah, okay, I got it. And then they come back a week later and go, now I don't understand. I thought I understood this, but so what I can do is I say, give me your questions in an email, and then I can explain it and they can go back and look at it. And anyway, so, the review process, again, typically depends on how quickly they are able to review the documents, how extensive their questions are, but it's not unusual for me to meet with a client, have the documents prepared, and have the documents signed within 2 weeks. The funding, as long as, if they provide me with a deed, I will have that deed ready for them at signing. And then all that has to happen is it gets recorded with the county clerk. If we walk it down, it's instantaneous. If we mail it in, it takes a few days. notifying the banks, all that kind of stuff. Again, you know, if that is something that they're handling, which is typically my situation where my clients handle their own funding, it's however quickly they can get down to the bank, because it really doesn't, it's not a long drawn out process. But if the question was with respect to just setting up the estate plan, 2 weeks is a good timeline. Yes, creating an estate plan, yeah, so.
I
Anything?
have one more.
Yep.
Is it typical for revocable trust to name both spouses as co-trustees? And then in that event, do both spouses have to sign relevant documents that are transferring assets?
So the question is, with respect to naming a trustee, or if a spouse or married couple are acting as co-trustees of the trust, do they have to sign documents transferring the assets, correct? Do they both have to sign?
Yes.
So yes, it is typical for a husband and wife to serve as co-trustees. That being said, when you're funding the trust, it's not the trustees that are going to determine what documents you have to sign. It's the owner of the asset.
Yeah.
So if an account is in both names, or a real property is in both names, then both people have to sign in order to transfer it to the trust. Now, if you are talking about taking things out of the trust, do you both have to sign? It would depend on what the trust says.
Yeah.
So typically my trust, unless I have a married couple that wants it otherwise, I state that they're both co-trustees, but that either of them can act individually on behalf of the trust. But again, that depends on what the trust says. Does that answer your question?
Yeah.
Okay. Cool. Anything else? Well, this has been really fun. I mean, I hope that it was useful. I hope that the information was useful. And yeah, it's still on the screen. Send me an email. If you have any questions that you didn't want to raise here, shoot me an email. I'm happy to address it, and I'll answer any questions that you might have. And if you need to contact me, the number's up there. You can call me as well. We have offices. I have an office in Albuquerque, also one in Placitas. So whatever's most convenient. If anybody wants to meet, I'm happy to do that too. But yeah, shoot me an email. So, okay. Then I guess it's a wrap. Thank you. Thanks, guys. That was great.